Hello, welcome back to the Matt Phifer Experience. I am your host, Matthew Phifer, and I have on a very special guest. I have Kala Arevalo. She is an attorney out of Dallas down here in Texas with me. And today we are going to be talking about divorce modifications. Oftentimes when we're talking about high conflict divorces, we're talking about the actual divorce process, but in a lot of situations, especially with a high conflict person, a high conflict personality that you might be dealing with, some things you might start to discover that you need a modification that you actually need to go back to court for, and especially when it comes to custody, when it comes to child support or other type of issues that might be lingering issues. But when do you actually go back, and what type of scenario, and maybe someone's threatening to take you back for some sort of modification. So we're going to have that discussion today. We're going to figure this out. We're going to put some pieces together to help you guys out. With all that being said, let's go ahead and get this show started.
Dream big, Papa told me dream big, cause all we take with us is the things we did. Dream big, yeah, just dream big, yeah, that's what my papa said. Dream big, mama told me dream big.
All right, Kala Arevalo, welcome to the show. Thank you very much. So I'm going to steal your line. Kala is an attorney, but she is not your attorney. So these are, as we're going to be talking about some of these tips when it comes to law, but we have to understand that every state is going to be very, very different. That's something that if you've been following me for a while, you guys know that I always share that as well, that your state is very different. So make sure that you connect with your local attorney. Make sure that you get a consultation with your attorney. One of the things I'm very, very adamant about is that you get the help that you need. But we can also take and hear some of the things that might be happening here in Dallas, Texas, and they might be applicable. Or if you're here in Dallas, go ahead and reach out to Kala for a consultation if she is available for consultations and if she is available for clients. So with all that being said, Kala, welcome to the show. And tell us a little bit about yourself and how did you get started in law?
Hi, well, I am Kala Arevalo, and like you said, I'm a Texas family law attorney. I'm not your attorney. In this video and these statements I'm going to make, they're for informational purposes. There may be some specifics in your case that may get a different result or things like that. It's just general information and kind of a starting point for you guys. And so I work for Cruz Law Group here in Dallas, Texas. We are a boutique family law firm, and this is all we do all day, every day is family law throughout the state of Texas. And we are primarily here in North Texas. I got started in law when I was 19 years old.
Wow.
I was interested in not in family law specifically yet, but just in being an attorney, and I just knew I needed to go work in Dallas and see if I liked it before I invested all the time and money in law school. So I came and I got a job as a legal assistant, finished up undergrad. I got an associate's degree in paralegal studies, continued to work full-time through my undergraduate degree, continued to work through law school full-time and going to law school at night. And I'm now a licensed attorney. And I've been a licensed attorney for almost 4 years now.
One of the things that you mentioned is that this is all you do. And one of the things I tell people is that when you're going through a divorce, make sure not only that they are a family law attorney, but that it is all that they do. One of the things that I've seen people make the mistake of finding an attorney who dabbles a little bit in criminal law, dabbles a little bit in family law, dabbles a little bit of everything. Can you talk a little bit about why it's more important to find someone who's specific to divorces and then to family law?
So especially when you're dealing with someone who's high conflict and you know that they're going to make the litigation experience a nightmare for you, you want someone who is going to be intimately familiar with the ins and outs of family law, not only with family law itself, but with your court as well. You want someone who's in the court before the judge, knows kind of their court procedures, policies, and even their personality to an extent, because that's going to benefit you in the long run versus coming in with someone who's not as familiar or doesn't know the policies and procedures or how to get things accomplished in that court. Because I think some people don't realize each court runs differently. Even the courts in Dallas, like Dallas has 7 different district judges, and each one of them run their courts differently. And so it's just going to make the experience easier if you have someone who's familiar with that.
One of the things I tell people is that when you're in the middle of especially these high conflict divorces, for you, it seems like it's like you just don't know what to expect. But when you're talking to someone like yourself, or if you're getting coaching from someone like myself, we see it all day, every day. So for you, you're like, man, I don't know what this person is going to do. I don't know what this person is going to ask. And we're like, okay, this is just another day in the office for us. And oftentimes we're able to kind of anticipate what someone is going to do based on oftentimes their past behavior. We may have seen that person. One of the things I tell people is that when you see your lawyer, they've seen people like this 10 times a day and all day, every day. And so when you're thinking of it like that, oftentimes people are intimidated to come see you, or intimidated to come talk to you about and get the consultation, because they think it's going to be weird, or whatever the case is. But oftentimes you like, or that you're not going to have the answers, but you oftentimes you do have the answers, and you are able to anticipate because you see it so often and it seems so clear. And for you, these type of personalities are actually like very predictable.
It is. I mean, you get kind of familiar just based on what court you're in and the facts surrounding a case. And I always tell people, you should always be honest with your doctor and your lawyer, right? You have privilege with lawyers. We're not here to judge you. And I promise you, I have heard and seen worse.
Yeah.
I have. And so I think people also get a little embarrassed. And so, I just try to make sure they're aware that I'm not here to judge you. Whatever you've done in your past, I just need to know about it so that we can move forward and go from there. And don't leave anything out. I mean, it's like I said, I'm not here to judge you. Lawyers are not here to judge you. We're here to help you. And the best way for us to help you is to have a whole picture.
So before we get into, I know we want to have the bulk of this conversation to be towards modifications, but let's kind of talk about the beginning stages. How do we either avoid modifications if someone's going through the divorce process, and how do we lay out that foundation to where we can make our life after the fact, after the divorce, either easier, or to simplify things? What are some common issues that you see, or common mistakes that you see in that divorce process that leads to modifications down the road?
The biggest thing that leads to modifications is not having a all-inclusive order that doesn't account for most situations. So if there's gaps in your order that don't account for different scenarios, then that's going to lead you to a modification, because you may not think it's going to be an issue, and then it becomes an issue. I think one of the most common things is omitting passport provisions in your divorce decree, and then all of a sudden y'all can't agree, you can't get a passport and can't travel or do things like that. I think that's a real common one. Or things like accounting for exchange locations if someone relocates, or long distance travel provisions if someone moves outside of the state and then y'all can't agree on how to exchange the child, so you're going to have to come back to court for a modification. I think the best thing you can do is have a very good final decree of divorce that accounts for all of those, to minimize the likelihood of coming back for modification.
And what about some of the day-to-day stuff? What are some things that maybe I know before we hopped on, we were talking about some of the things in terms of people still having ties with their former partner. One of the things I tell people is to make sure that you do the divorce the right way the first time. And what I mean by that is to cut every single tie you have with them outside of the children. One of the reasons why I stress that is that we have to understand that for 10, 15, 20 years, you obviously, and especially in a high conflict situation, you didn't get along with this person. That person likely was very controlling, and the likelihood is that they want to continue that behavior even after the divorce is over with. And if you guys still have houses in each other's names, boats in each other's names, cars in each other's names, that can be very, very problematic. And not only in the divorce, after the divorce, but it also becomes very problematic. And if someone tries to go for a modification, can you talk a little bit about that?
So from the property aspect, it's a little more difficult. That's why it's so important you have a divorce decree that encompasses everything, because the court can't go back and retroactively modify the property division. And so if he's if the person who's supposed to refinance the house isn't ordered to do so in the court order, the court can't come back and tell them to do it. You're going to be looking at like a separate civil suit, which is going to cost you more time and attorney's fees. And then you also need those contingency plans in there as well, because you can't guarantee that person's going to be able to refinance it. So you need a default clause that if it's not refinanced by a certain amount of time, then that house has to be sold, because you can't have those ties, especially when you're dealing with someone who is controlling and kind of uses that as a way to have communication with you or to just be involved in your day-to-day life, which you get that when you're in a high conflict and sometimes even volatile relationship. So you just need to make sure that you cut ties down to minute things that people sometimes don't think about. Like, do y'all have joint Amazon Prime account that has like different videos, or your iTunes library that has music and things like that? I mean, it doesn't seem like that big of a deal, but you want to make sure you cut it clear, because I mean, you would not believe the amount of times I have people in a divorce case that their ex will play hateful music and have it going off while they're listening, just to create that conflict.
Yeah.
You want to make sure you cut that off to limit the amount of conflict in your life.
One of the things I see pretty often that people hold on to is two things: insurance and the phone. Keeping the phone plan in each other's names, and that's one of the things I tell people that needs to be one of the first things to go, is because one of I remember I was dealing with someone dealing with a client who we always have to. One of the things I tell people is we always have to prepare for when they're upset, and when we're talking about people who are high conflict, anything could make them upset. So this client, their kids went out of town, they were out of state, and the ex asked this person out on a date. And when the person turned them down, they called the kids in the other state and said, "I'm sorry for what's about to happen, but blame your mother for this," and shut off everyone's phone so no one could talk to each other. And the kids were out of state. And these are the type of things that happen after the fact, and this was after the divorce. And I think to what you're talking about in terms of that person holding on to control. But it sounds like a lot of times people are saying the right things to try to make it seem like they're trying to be cordial when they're really actually not.
Yeah, it's definitely a false misrepresentation of their intentions, right? I'm going to continue to pay your phone bill because I'm a good person, but really I want that control. So when I'm upset with you, I can inconvenience your life.
Right.
And so it's just something to keep in mind, and make sure you get a clean break from it.
Tell us a little bit more. Let's talk about the kids, because obviously that becomes very problematic, because that's something that we do have to keep ties with. And when we talk about, and also this, oftentimes people will make threats to modify things.
Mm-hmm.
So let's say that, we have a custody order in place. Let's say that it's 50-50. And oftentimes, let's say the person starts dating again. I think that's a common scenario. You start dating again, and immediately the person finds reasons to say like, "I'm going to take you back for full custody. I'm going to take you back for child support. I'm going to take you back for these sorts of things." And when you're in the middle of it, these seem like real, actual, credible threats. Can you talk about how to know the difference between like, yeah, I need to take this serious versus this is an empty threat?
So the burden for modification, there's a couple of different ways, right? So if you're going to modify your conservatorship or your visitation schedule, they have to show a material and substantial change in circumstances. And that just sounds like a super vague statement, which it kind of is. But something like you're dating again, or that's not going to qualify as a material and substantial change as long as the children are taken care of. As long as you're not doing something that is harming the children, they're still getting to school on time, their grades are still good, the person you're dating is not a registered sex offender or extremely violent criminal that's around the kids. Those are not usually credible threats. But that doesn't mean they won't try to find something to create that drama to bring it back. So you just have to make sure you're doing everything you're supposed to. Making good decisions and being a good parent.
Right.
For child support, it's a little it's going to be numbers. So if there is a change in circumstance financially, you have a new job, you're earning more money, if one person's not exercising all of their visitation, things like that would probably get the court's attention to look at the circumstances and see if something needs to be modified. And so child support is kind of a different entity because we have a provision in Texas that you can review child support after 3 years just because. You don't have to show that material and substantial change in circumstances. You're just entitled to a review every 3 years.
Yeah.
In order to do it before the 3 years, you have to show a material and substantial change in circumstance, which means that the child support would differ by either $100 per month or 20% of the current amount. And so if you're earning more money and the other side may just be mad at you and like, well, I'm going to get more child support, even though their intentions are because they're mad. If your financials are different, the court's probably going to change it.
Right. And vice versa, it sounds like.
Yeah.
Yeah. The to kind of piggyback off of the, that there is credibility to make changes. One of the things that happens pretty frequently is when that person is not, the pickup and drop offs always become a nightmare. They're coming late, they're not showing up at all, they're showing up early, they're not meeting at the proper designation, those sorts of things, and they're just non-compliant with the decree and with the order. Is that something that can be modified? Is that something that should be modified, or is that something that it's like, okay, I just need to suck this up?
So it's going to depend, because to be honest, the court is not going to care if your co-parent is like 5 minutes late pretty consistently, 5 to 10 minutes. It happens. Like, they expect you to be reasonable.
Right.
Now, if you have an issue where the exchange is at a neutral location and you're driving over there and they're not showing up, then yeah, the court's probably going to modify it, and you need to keep track of when that happens. If it happens one time, that's not sufficient.
Right.
If it's something that happens repeatedly, and not only is it inconveniencing the person who's driving there, it's very emotional for the child too, to get in a car, go over there, expect to see the other parent, and then they don't show.
Yeah.
And that's kind of an emotional roller coaster for the kid as well. And so then the court would probably modify it. Usually they would make it at the parent's residence if that's a safe option. That way they're not like driving out somewhere. Mm-hmm. Or the courts even do things sometimes where they require you to confirm your visit the day before. Mm-hmm. You have to send written notification. Yes, I'm going to exercise my visitation. That happens when it's a very consistent issue.
Is that the case also if someone doesn't want to follow the decree at all? They're either not showing up on the weekends, or they just try to change it altogether, and they try to be demanding, like, I'm getting the kids this weekend, and it's not their weekend. Is that something that's common? I know in my neck of the woods, I see that pretty frequently. And what should someone do in that situation? And is that something that should be addressed?
Yeah, you tell them that, no, we're following the court order. I get so frustrated when people think that they can unilaterally change their court order. Like, no, you can't. I have parents who think they can just deny visitation, be like, I'm not taking the kid today because, I literally had a case last week where she's like, well, he took him out of state to Oklahoma and didn't tell me. He's not obligated to. He had the kid there and back on time. You don't get to stop visitation. And the court was upset. They went through the order page by page and made her read it.
Yeah. Wow.
So, and then on the flip side, you have the non-custodial parents who think they can just dictate when they're going to get their visitation. They're supposed to pick up Friday at 6, but now they want to pick up Saturday at 10 a.m. Mm-hmm. And, I always tell people you should co-parent if you can, right? If it is reasonable, if it's an accommodation, do it. It's going to work better for your kids. I think the psychology is very clear that regardless of the possession schedule, the children prosper more when the parents have less conflict, or they're not aware of the conflict. Mm-hmm. And so that should be your priority. But when you're dealing with someone who's doing it purely out of control and to just have that interaction with you, you're not obligated to. Literally tell them, that's cool, take me to court, because they're not going to be successful in something like that when you're not obligated to change the schedule.
One other question I have in terms of the kids is, let's say another 50-50 case, or someone has, a decent amount of visitation. One of the things that you hear about a lot is the extracurricular activities, or church or religious events and that sort of thing. One person is highly spiritual, the other one is not at all. One of them wants to allow for them to watch scary movies, the other one doesn't at all. One of them wants them involved in basketball, football, everything. The other one doesn't want them involved at all. Whether it's a control issue or not, one of the things I tell people is that it's important for you to know your rights, but you also need to understand that the other parent has rights too. And how are those type of situations handled? When you have polar opposite, regardless if it's control or not.
So there's two separate issues, right? The religious one is always a big issue. And if you look in your Texas order under your rights and duties, it's going to say that each parent during their period of possession has the right to direct the religious upbringing of the child. So you can't force the other parent to uphold your religious beliefs in their house. You just can't. And extracurriculars are a little bit different. And that's something I always recommend clients to have in their court order. If something's happening when the kids are young, 3, 4, you don't think about it as much, and it becomes more of an issue when they're older. And typically the courts want both parents to take them to extracurricular activities. However, if you're dealing with a parent who's enrolling the child in all of these extracurricular activities just to take up your time, that's a little different. And so that may require a modification. And typically what I see the courts do is say each parent can enroll the child in one extracurricular per year, or the parents are obligated to take the child to agreed upon extracurricular activities. Just to put some provisions in there, that's going to vary wildly case by case, because a lot of it will have to do with the child too. If it's the child wanting to do these things and they express that, and the court's going to probably be more inclined to order it. Or if they're older and they're in that stage where they have these, collegiate opportunities, the court's going to want to make sure you take them to their, club soccer or their whatever they're doing. But.
And what about, go ahead, I didn't mean to cut you off.
No, you always have to keep your kiddo in mind. It's so easy to get caught up in the anger you have for the other parent. You have to love your child more than you hate your ex.
Yeah.
And really take that into account. Like if your kid really wants to go to the extracurriculars on your time, take them.
One of the things I hear, I want to touch on two different issues. I'm going to be talking about smear campaigns here in a second, but one of the things that came up that I just thought about is another thing I see is where people want to take people back for modification because the person is overly dating. And no judgment to anyone who this might be the case, but someone who might have a new person in their life every month. They might be on the dating scene, or they're introducing the kids into someone every 6 months. Or maybe in some situations, they're not actually introducing the child, but oftentimes the other parent has an issue with the fact that this person is dating someone new every 6 months, every 3 months, or whatever the case is, and they think that is something that can be brought up, or on the flip side, the parent might be going to happy hour every other day, or things like that. Where's that line where a parent can have their life and where it's inconveniencing the kids, where and we can talk about it from both ends, where when do we need to be concerned that this person has justification for modification, or on the flip side, we're the concerned parent and we're like, we need it's time for us to do and time for us to act here.
I think the first thing is, if they are doing it when they do not have the child, it's not their period of possession, it's not your business. The court's not going to care because your kids aren't there. And as long as they're not like being violent or harmful or something like that, they're free to do what they want on their free time.
Yeah.
Now, if you get into a situation where the parent is going out while they have their period of possession, and it is frequent, like multiple times a week, and the kids are either home alone or always with someone else, or they're not getting their homework done or getting to school on time the next morning, things that start to adversely affect the children, that's when the court would likely intervene. Yeah. With the dating, again, if you're dating and they're not meeting the kids, the court's not going to care. They're not
Yeah.
going to care.
Yeah.
And if you're introducing a new person to your kiddos constantly, that the court's going to have a concern with that because it's not teaching healthy boundaries and relationships for your kiddos to kind of have that revolving door going on.
Right.
And it's confusing for them too, especially
Right.
young kids.
Hmm.
So, you know, your kids don't need to meet every guy you date or hook up with or whatever, right?
Right.
And that's just something to keep in mind. You can
What
date,
about
you can be in the streets all you want
right?
during free time.
Right. What about people who when kids say things like, regardless if it's the other parent who is coaxing, who's causing them to say this, but I want to go live with dad. I want to go live with mom. I don't want to be here anymore. And sometimes that child might be pressured. Is there any? I guess let's give two different scenarios. Let's say that the child is under 10, and then let's say that they're um, over 10, maybe closer to like 15, 16 years old. Um, is when should someone be concerned in that type of situation?
Okay. So in Texas, our age is 12. It's 12. And that does not mean your kid gets to make the decision on what they're going to do. It means that they are allowed to speak to the judge or to the court counselor or whomever the court appoints to state their preference on what they prefer to do. Okay. It is discretionary under 12. The court can order it if they're like 10 or 11, they usually do. It's not mandatory though. But at 12, if your child has a preference and someone says, I want my child to be interviewed, the court does not have an option. They have to interview the child. It doesn't say when the child has to be interviewed, if it's early on in the case for like temporary orders or if it's at final trial. But your child has the ability to state their preferences. And then the court is going to take that into consideration when making their recommendation. Now, when you get kids that have driver's license and they're driving like 16, 17, it is harder to make a 16 or 17-year-old do something, right? You can't physically make them get in the car. You can't, it gets harder. I don't want to say you can't, but it gets a lot harder when they're that age, and the court is more inclined to give weight to their preference when they're like 16, 17, and assuming that it's not blatantly clear that they're wanting to go to the other parent's house because of a lack of rules and more freedom. They get to get away, not go to school, do things like that.
Right.
So even if they want something, if the court it's obvious it's not in their best interest, then the court won't order it. But that age makes a big difference.
What about in terms of the other parent bashing people online post divorce? And I see this all. You see, both of us are on TikTok. We see this all over TikTok. And I've talked to people about. I've made videos about not going for revenge, and you hear people, well, if I'm telling the truth, it's not a smear campaign, and I'm like, yes, it is, and yes, it can still have a major impact on you in court if you continue down this line. And we had Judge Anthony on here. One of my favorite lines with him is, "It's you doing that. It's definitely not going to win your case. It most certainly can lose your case." Can you talk a little bit about smear campaigns and the people telling the truth and just I'm just venting my side of the story and how that actually can cause a lot of problems and conflict in court?
So there's a fine line, right, that people have to balance between your freedom of speech and then, not making disparaging remarks about the other party or things like that. I think one of the things the court is really going to consider is if you're posting on a public forum and your kids are on social media, like your kid's your friend on Facebook, they follow you on TikTok, and they see you making these things, the court's going to be even more upset.
Mm-hmm.
And so for me, as someone who's active on social media, I tend to personally side more with like people are able to make their own their own content and speak their truth. But from the lawyer side, it's like, even if it is, the courts don't like it. They don't like it. And especially if you go in there and you're talking bad about your court, which it kind of seems like a double-edged sword, right? Like, you should be able to speak your truth, and it may seem like retaliatory that they use that against you, but you want to put yourself in the best position possible for court.
Mm-hmm.
And the best way to do that is to not piss off your judge.
Right.
And
And one of the things about pissing off a judge is that when you go back to modification, it's oftentimes the same judge.
it is. Dallas County, they run 4-year terms, I believe. And yeah, so
Yeah. And I want to be very clear, like people who are, really struggling and maybe the victim of some sort of abuse, like one of the things I tell people is that you should tell your truth, but on a public platform is probably not the best situation. There are plenty of support groups. There are plenty of therapists, coaches, other people that you can do that in private, to where it's not being used against you. And so just consider doing that for your healing, rather than doing that on a public platform.
And another thing people run into a problem with is that you're saying your side of the story, and there's a whole other side to it.
Right.
And so I've had an issue with one in particular who started a podcast and is on all the social media saying, they're alienating and keeping the kid away from me, but they failed to disclose important things like, failed drug test, eviction notices, unstable housing. Like, there's just little things that you're not telling the whole truth, though.
Right. Absolutely. Can you talk about the other side of it, when someone is actually saying disparaging remarks against you and some sort of smear campaign against you?
Yeah, you can ask for injunctions from the court, and it's going to depend on your court. A lot of times the court will make injunctions which prohibit a party from talking about the litigation or making disparaging remarks online. A lot of courts order it. There's a lot of legal debate about it right now, whether they can do that or not, and whether that's constitutional or not, but the courts do it. And so if that is an issue, especially if you can show it's on a public forum or the kids are seeing it, a lot of courts order no posting about the litigation on social media. And I don't know if you remember the case that I Am Sophie or Save Sophie out of Collin County. The dad had posted a ton of things about the child not wanting to go with mom, recorded her. It went completely viral. I want to say 2 years ago in Collin County.
Mm-hmm.
And people were on his side. They were protesting at the court's house and doing all of these things. Like, they went and found the judge's physical location.
Yeah.
And later it turned out, he had, all of the claims had been investigated by like CPS, by the police. He had some troublesome outcomes for his psychological evaluation, I think is what the records were saying. And he ended up kidnapping the little girl.
Wow.
And so they did find her. I think they found her a few months later in another, I can't remember if it was another state or country.
Mm-hmm.
It was just an example of how so many people rallied behind this person because of social media, and they just didn't know all the facts, and it put a lot of people in danger. People typically rally around the very first thing they hear, rather than listening to both sides of the story or hearing things. And I know, and I get it, people say, like, people don't believe victims and people don't believe, people won't believe me. But unfortunately, people use victim stories as a way to manipulate and a way to try to gain sympathy from people, unfortunately. So it's just an unfortunate situation that's just kind of the state in the world that we live in. Yeah, that wasn't my case, so I don't know the details intimately, but I know when I heard about it, I started doing some research on it to look at it, because it wasn't adding up to me as a family law attorney, and it's something you really have to be aware of when your clients are on social media. Can I just say, don't make secret accounts, and don't tell your lawyer about it either, please? Thanks.
Can you talk a little bit about, well, I was just about to end things, but that you just left us with a little too much juice. Tell us a little bit about why and what happens there, because I see and I hear that all the time, and clients might say to me, that they do that, and I'm like, and I talk about that from a healing aspect, that stop stalking your partner on social media and things like that, we got to start letting it go and start practicing radical acceptance. But from a legal standpoint, why is that?
Oh, because I check my clients' social medias. I go through them. You can, once you're in court, there's standing orders for most counties, which means there's certain things you can't do, including deleting evidence from social media, changing accounts, or whatever. And, but if you have an account I don't know about and you're using that account to post things that are damaging to your case, as much as you stalk your ex probably stalks you too.
Yeah.
And they find that secret account and it just creates a problem. And then your lawyer is caught off guard in court by it. And, you can't outbeat the system as much as you think so. Someone is sending those screenshots to your ex.
Yeah. And just like we said, or just like we said at the start of the show, as this might be, even if this is your third divorce, people who are attorneys, people who are divorce coaches like myself, we see it all day, every day. And so all these little tricks that you might think that you're going to get by with, regardless if you think that it's a shortcut to healing or a shortcut in the legal system, it's not going to cut it. We've literally, and the judges, same thing, have seen literally just about everything. Kala, thank you very much. It has been amazing. We're going to have to do this again because you are very knowledgeable, and I could tell just by some of the comments that this has been very helpful for people. If someone wants a consultation, someone wants to work with you or wants to know more about you, where can they find you at, and how can they work with you?
Yes, call me. I am at Cruz Law Group here in Dallas. I'm one of my amazing assistants, Yessie or Masha, can get your information and get a consultation scheduled. Our phone number is 214-661-1500. And then also my TikTok handle, I post content there pretty regularly, is just my name, Kala Arevalo, as you see it on your screen. And on there, I have a link tree with contact information for our firm and things like that, so you can get a consultation scheduled through that. It's also on Instagram as well, my link tree.
Awesome. Ladies and gentlemen, that was Kala Arevalo. We appreciate her hopping on. If you are listening on the playback or if you're watching on the playback on YouTube, comment down below some takeaways, some concerns that maybe that have been addressed today that that was some tips that may have been helpful for you. If you're listening on Spotify or Apple Podcasts, leave us a review. We love reviews. Every once in a while, I take time out and I read reviews right here on the podcast. This is the Matt Phifer Experience. I am your host, Matthew Phifer. We appreciate it. Make sure you share this out to people who might be going through a divorce modification or going through a divorce process. With all that being said, thank you guys very much, and we will talk to you next time.
Dream big, Papa told me dream big, 'cause all we take with us is the things we did. Dream big, yeah, just dream big, yeah, that's what my Papa said. Dream big.